another San Diego ASA News Brief. This is Eugene Davidovich reporting from San Diego. As of January 1st, the penalty for possession of an ounce or less of marijuana in California is now the same as getting a parking ticket. Prior to January 1st, possession of an ounce or more was a misdemeanor punishable by a fine of up to $100. The new law, Senate Bill 1449, makes it an infraction and essentially decriminalizes possession of small amounts. State Senator Mark Leno is who introduced this bill, and in the fall, Governor Schwarzenegger signed it. To make sense of the new law and its effects, we have turned to two legal experts here in San Diego. First with us we have Mr. Michael J. McCabe, a criminal defense attorney who has been practicing law in the city for over 37 years.
Welcome, Mr. McCabe, and thanks for joining us.
Thank you.
With Senate Bill 1449 taking effect over the weekend, how does this affect the current cases that will be prosecuted?
Well, first of all, what this bill did was to make simple possession of less than 1 ounce of marijuana, that is 28.5 grams, punishable as an infraction rather than as a misdemeanor. Under previous law, even though under Section Health and Safety Code Section 11357B, the maximum penalty which could be imposed was a $100 fine, it was nevertheless designated to be a misdemeanor rather than an infraction. The difference here is that one can be arrested for misdemeanors, whereas unless you refuse to identify yourself and do not have identity, or there's some question as to your identity, you cannot be arrested for the commission of an infraction.
Previously, when this was a misdemeanor, possession of under an ounce, that is, these cases were tried in the state courts. It being an infraction now, where would a case like this be tried?
Well, it would still be tried in the state courts, but since it is a misdemeanor, an infraction, you would not be entitled to a jury trial at that particular point in time, since you do not have a right to a jury trial in an infraction. So one would hope that the city attorney's office, which is the main prosecuting agency for the city of San Diego, or the district attorney's office in the outlying courts, would think a little bit more about filing a charge such as this one, given the fact that it has such a de minimis impact. Overall, it will save the taxpayers, I believe, a great deal of money by eliminating a class of arrests, which then result in much greater cost in terms of processing as well as incarcerating individuals who are unable to make bail on this sort of a charge. Lessening the criminality of it cannot help but advance the cause by making the possession of marijuana equivalent to a traffic ticket. It's definitely a step in the right direction.
Melissa Bobrow is also a criminal defense attorney and active member of San Diego Americans for Safe Access, who specializes in marijuana-related criminal cases.
Melissa, so how do you think the new law affects law enforcement here in San Diego or across the state?
Well, first of all, I think it's wonderful. I think it's long overdue that the state finally recognizes that simple possession of marijuana is not in fact a crime and at most an infraction, perhaps. Well, I think this is a big sigh of relief. I think that everybody now knows that the absolute worst case scenario, if you have an ounce of marijuana on you, which is a common amount for many people to carry on them, that at worst they're looking at an infraction, which I personally believe patients should be still willing to fight, but that at absolute worst case scenario we're no longer looking at jail time or heavy penalties and fines and being marred with the concept that you're somehow a criminal for simple possession. But I just think it's a step in the right direction. I think that the process is long and that it's another critical step.
To weigh in on this issue from a patient's and activist's perspective, with us today we have Terrie Bess.
Hi, Terrie, and welcome to the program.
Hi, Eugene. Thank you.
Having heard the opinions of Mr. McCabe and also Melissa Bobrow, two local criminal defense attorneys, about the recent Senate Bill 1449, what kind of an effect do you think this may have on either patients or the criminal justice system?
When you're talking about enforcing citing people for victimless crimes, the person who's committed the crime or allegedly committed the crime becomes the victim, in my opinion, of the court system. And it concerns me that this is open for abuse by the DA and the city attorney's office.
How so?
I'm afraid, first of all, I think this is a great step in the right direction, and I don't want to belittle the process, but I think that occasionally a DA might put a bunch of other charges in there in order to get you to be the perpetrator to become scared enough to plead to a misdemeanor rather than an infraction. I just feel it has some potential for abuse, and I just would really encourage patients who have the legal right to possess marijuana not plead guilty to an infraction, because really we have a defense against the infraction. We are legal patients.
The folks against this issue say that this may send the wrong message to our children. Do you think this sends the wrong message to our children?
It isn't a crime to smoke marijuana. It isn't a crime to medicate for one's ailments, and I think it sends a message of compassion to our children.
How so? Don't you think this would basically say that it's okay? Do you think it's okay for children to smoke marijuana?
No, I don't think it's okay for children to smoke marijuana, and I hope that they make the right choices. Their parents guide them through that.
Thanks for your time, and thanks for joining us today, Terrie. We really appreciate all the great work you do in our community.
Thank you.
Thanks for tuning in to another San Diego ASA News Brief. Get involved, get active, make a difference. And visit our webpage at safeaccessse.org. Join ASA. Visit safeaccessnow.org. To see all of our news briefs, please visit our channel on YouTube at youtube.com/safeaccessse.